Of course, your comments are welcome. We are live on X Spaces, on Facebook, on YouTube, and of course on myjoyonline.com. Your comments will be shared here on this program. This is a pause. My name is Elton Brobe. Now, this afternoon, we are starting from the stables of the Supreme Court of Ghana, and the court has, by a 2-3 decision, dismissed an injunction application by the Member of Parliament for Old Tafo, Vincent Asafua, challenging President Mahama's decision to suspend Chief Justice Gertrude Tokono by a 3-2 decision, with Henrietta Mensah Bonsu and Ernest Gau dissenting. His Lordship, Justice Bafuboni, Justice Amadou Tanko, and Justice Yoni Kolende voted to dismiss the application. Now, let's take a look at how the voting went. And of course, so this is how it went down to the Supreme Court dismisses injunction challenging the Chief Justice's suspension. So the 5 members that sat on this panel, 3 out of them voted to dismiss the application. And my colleague Latif Idrisu is our legal affairs correspondent. He's in the studio and he's going to help us walk through the graphics as we have it. So Latif, if we can help understand them of what we have on our screens this afternoon.
Yes, so just to deal with the graphics that we have. So we have 5 members sitting on the panel. And let's state for the record that this is a different panel compared to the panel that started this particular case. And we'll get into that, I'm sure, going forward. So we have Justice Geu and then Justice Henrietta Mensah Bonsu, both of them dissenting. And then we have Amadou Sule, Justice Amadou Sule. We have Justice Bafuboni, that is the acting Chief Justice, and then Justice Yoni Kolende, all 3 of these voting to dismiss the said application. And you have it on the screens right now. We have the acting Chief Justice, Justice Bafuboni. We have Justice Amadou Tanko. We also have Justice Yoni Kolende. So these 3 you find on your screens voted to dismiss the application brought forth by the Member of Parliament for Old Tafo. And then you have 2 other judges who voted to sort of dissent on the application. So you have Justice Henrietta Mensah Bonsu and Justice Ernest Geu. These were the dissenting voices.
They voted to say that the application
must hold.
Must hold.
Yes.
And that, according to them, the suspension was not right.
Not right. And so the warrant that was issued by the President to suspend the Chief Justice, according to these 2, Justice Henrietta Mensah Bonsu and Justice Ernest Geu, that must be respected, and the President's order has to be suspended. All
right. So initially, this was not a panel initially.
Exactly.
This panel that took the decision today
it's a reconstituted.
Went through some kind of modification.
Exactly.
So first, let's establish the initial panel that was constituted by the suspended Chief Justice.
So those who are absent on this particular panel are Justice Wamang and then Justice Asiedu. And now we all know that these 2 justices have been appointed by President Mahama to sit on the committee that is investigating the allegations as captured in the petitions. So they couldn't have been present on this same panel, hearing the matter, and then be on the same committee that is going to investigate the allegations that have been made. Clearly, that would occasion some level of conflict, if you like. And so that was the argument that Justice Amadou Tanko made to the learned lawyer, the former Attorney General, Godfrey Adame, when he insisted that the acting Chief Justice
himself
ought not to be on the panel.
On this panel.
Because in the minds of the former Attorney General, Justice Bafuboni stands to be the ultimate beneficiary of the outcome of the procedure that has been triggered by the President.
That is, in event that Gertrude Tokono is removed as Chief Justice of the Republic.
Exactly.
Because he is already acting.
Exactly. So, and then for someone who stands to benefit, you cannot set up a panel.
You take a decision that affects the person for whom you are acting in her capacity.
Exactly. Because you benefit at the end of the day. Then the argument by the panel was that, no, they quoted Article 1446 of the Constitution and says that once he is acting as a Chief Justice, that is an office that he, as a person, is occupying.
Right.
He is not barred from undertaking his role, his duties as an acting Chief Justice. And so the argument by the former Attorney General doesn't hold. In fact, this particular section went on for a very long time. It was back and forth with the former Attorney General quoting some provisions in the Constitution, quoting some papers that have been published, quoting the Ghana Law Report from the 80s, and all of trying to make a case that indeed Bafuboni ought not to sit on the panel.
And the decision after all the back and forth, after all the arguments, was that?
So there was a unanimous decision
that all of them voted against the application by the former Attorney General.
That Bafuboni ought not to be on that particular.
And so clearly this was a unanimous decision.
Unanimous. Then there was another objection by the former Attorney General, which had to do with the constitution of the panel itself. I think that's what we have just dealt with.
Right.
So it had to do with Bafuboni also. I think we've dealt with that one.
Exactly.
So those were the two objections that were dealt with by the panel. They dismissed all two. And then
after this, they moved to the matter of the injunction.
Of the injunction, exactly. So on the matter of the injunction, that was when we had the decision that the president is performing a constitutional duty. And per the Constitution, you cannot enjoin someone from performing a constitutional duty. In fact, there was the issue of timeline that, the case of the former Attorney General was that failure by President Mahama to notify the suspended Chief Justice that I have received some petitions asking for your removal. Failure by President Mahama to do that constitutes a constitutional violation of the rights of the suspended Chief Justice. Now, it was the position of a panel member that the former Attorney General should point the panel to the section of Article 146 that stipulates the timeline within which the president ought to notify the Chief Justice that I have received a petition asking for your removal. In fact, that one is not available. It's not captured anywhere in the Constitution. And so the Attorney General could not point to that particular provision in the Constitution that stipulates timeline during which the president is expected or supposed to notify the Chief Justice once he receives a petition asking for the removal of the Chief Justice. It doesn't exist. And so, again, back and forth, and that was when the decision was made that by 3-2 majority decision, that application has been dismissed by the Supreme Court.
Meaning 3-2, it was not a unanimous decision.
It wasn't a unanimous decision.
3-2 means, in the minds of the two, they had a case.
Exactly. So in the minds of Gewu and Henrietta Mensah Bonsu, the argument and the position of the Old Tafo MP, the submission by his lawyer, the former Attorney General, hold some substance. And so they went that direction and they voted that the warrant issued by the president must be withdrawn and the Chief Justice reinstated to her substantive position as a Chief Justice.
And then the other three, led by the acting Chief Justice, is of the firm belief that there is no case.
There is no case, and so they dismissed all the application filed by the member.
All right, let's listen to the former Attorney General Godfrey Dame after the court, after the matters in the Supreme Court. He spoke to the media. Let's listen to him.
Just your initial reaction to this particular ruling.
Well, I think that I find it quite intriguing to start with that the acting Chief Justice himself will preside over the proceedings. And as I indicated, I find it very incongruous because indeed if at all there's any beneficiary from all of these developments, it is the acting Chief Justice. He's been a direct beneficiary of this. Of course, it's a constitutional injunction for him to act as the next most senior. But clearly, we cannot lose sight of the fact that whatever has happened, the benefit of it accrues to him. And it is incongruous in the constitutional history of this country. We've never seen any development like that before. Whenever there has been a dispute as to the status of the Chief Justice in this country, start from 1980 for an Attorney General, start from 1993, 94, Aban, and we go to 2005, there about J. Truman, the Chief Justice in question, and panel the court, but never sat on the matter. I mean, so it cannot be right for the acting Chief Justice to sit on the matter. But that's it. We see the 3-2 ruling, very narrow decision. We wait for the reasons. When the reasons come, we definitely advise ourselves. The narrowness of the decision itself indicates clearly that the application, no doubt, had merit and we know what to do. All right?
Your main argument, your final was the fact that the president's failure to notify the Chief Justice from the outset constitutes an egregious constitutional violation. But one of the panel members pressed you. He wanted you to point the panel to the clause in Article 146 that clearly stipulates the timeline.
The reasons for the decision have not been known. Of course, clearly, I mean, the spirit of Article 146 we're talking about. In the first place, it is important to indicate that nowhere in Article 146 will you find the requirement for prima facie determination made for a Chief Justice. But the Supreme Court itself imported that into Article 146 in 2005 when it authenticated on the J2 matter. But of course, the Supreme Court was silent on whether there ought to be notification to the Chief Justice and obtaining of his or her comment before triggering the process. And that is what is in dispute before the court. And my contention is that natural justice, all the rules of constitutionalism and all will require that there ought to be such process.
Right, so that's the former Attorney General Godfrey Yeboah-Dame, at some point flagged by the Ekwasuman, who was the legal counsel to President Akufo-Addo during the 8-year administration of the president. Now, there was a response from the Deputy Attorney General who represented the state in this case.
Yeah, his point is that the judgment of the court is a position they have held over the period, that indeed there's been no breach by the president has not violated any constitutional provision as, suggested by the learned former Attorney General Godfrey Yeboah-Dame.
I get to see the reasoning. So when we see the reasoning, of course, then we will know whether the court listen dissented, the justice dissented, or dissented. There was any reasons for it. There are so many reasons why the court dissented, but you were taught and you realize that the question was consistently put. What exactly are you alleging? What is the right that you are alleging? And to pile up a series of newspaper publications claiming that because newspapers are published that the president is attacking the judiciary, that is enough for the president to stop the process. So the process is unconstitutional because newspapers are published. That cannot be a very strong legal basis. And you saw the attachments of newspaper publications, many of them. I don't think that publication is a legal right or determines the legal right for anyone.
Okay, so for the decision that has been taken today, what does it mean to the process that is currently before the committee that is supposed to be?
Well, it means the process will go on. The process will go on. The committee would sit, would hear the inquiry into the matter. And of course, I have always maintained that the finding of prima facie case is not automatic that the Chief Justice or the person who is being who is the subject matter of the petition has been removed. It is not at all. So it may come out that the Chief Justice, the petition has not been of merit, and the Chief Justice will be restored to her position. I am always surprised that people have concluded that the fact that prima facie case is found and means that the Chief Justice automatically removed from office. You see, that is what actually motivates this petition, this motion that have been filed. I think the underlying understanding, which I consider a misunderstanding, is that the plaintiff believe that when the prima facie case is established, then it's a gone issue. But it is not.
All right, so that's Justice Rimsai. He is a Deputy Attorney General for the Republic, and he was in court today. Of course, your comments are welcome via our social media handle, X Spaces, YouTube, and of course, my Online or Facebook as well. Now, the man who took this matter to the Supreme Court seeking some kind of intervention joins me in the studio this afternoon, Vincent Ekwasifwa. Vincent, you're welcome to the show.
Yeah.
And you were a lawyer yourself.
Right.
And so let's start from the very top. Your counsel, in this case, the former Attorney General, had issues with the composition or with the paneling of the judge that sat on this particular case. Why did you raise that objection in the first place?
No, I think that first and foremost, it was not only about the empaneling per se. It was first and foremost about the CJ, that is the acting CJ, sitting as a member of the panel.
And you had issues with
that? That was our first objection.
Why?
Because we believe that for purposes of appropriateness, and so when lawyers or when we say that justice must not only be seen to be done, but it must be done. Or justice must not only be done, but it must also be seen to be done.
Right.
It would have been in the interest of Bafuboni. And when I saw him entering the courtroom, I was surprised, like, what is happening? Because the initial paneling, or the initial panel that was supposed to have heard the matter, or that was hearing the matter, was not inclusive of Bafuboni.
Right.
And so our first objection was, why is the acting CJ sitting on the matter? Because it is our respective opinion that he is the beneficiary of the suspension. So it is not about the constitutionality of it. We also did not attack the constitutionality of whether or not Justice Bafuboni could empanel the bench. No. Our case was premised on the fact that please let it be seen that what is going to happen in this room will be fair and will be just, not necessarily what will be constitutional or what will be legal. And so it was our respective opinion that Bafuboni was not properly constituted to sit on the matter. And for that matter, it would have been in his own interest and the interest of the people of Ghana for him to have recused himself from chairing the panel. Of course, these arguments...
So from the onset, you had issues of bias against him.
Absolutely. That's what I'm saying, that this particular matter is a very crucial and, an important matter where a CJ has been removed.
Suspended.
Has been suspended. And you have been made an acting CJ because of that suspension.
So he's already benefiting from that vacancy.
So why don't you allow other justices of the Supreme Court to sit on the matter so that it will be seen and it will be apparent on whatever is happening that indeed justice is being served, that indeed the process is fair, that indeed whatever is happening is just. And this was our argument, that the appropriateness of it was very critical. You see, you remember what happened in 2012.
Right.
And I use this example not to mean that that is exactly what is happening today, no. But the rationale and the principle behind it, that His Excellency President Kufuor appointed Georgina Wood as a CJ. In 2012, when the New Patriotic Party took the matter
in the election petition
to court, the CJ could have started the matter, but did not, because the party that has brought the matter to court, and if anybody wants to juxtapose this example to that of the 2021, I will also explain to you why it is different. The party that has brought the matter to court, that party's leader appointed her as the Chief Justice. And for that matter, it was proper for her to recuse herself or for her to distance herself from the hearing of the matter so that it will be seen.
Basically because she was appointed by former President Kufuor.
It is constitutional, and it would have been constitutional if she had sat on the matter.
But
the appropriateness of it was what I believe made her believe that she should not sit on the matter, even though she could have sat on the matter.
But again, the response we are getting as the reason why that particular application was dismissed unanimously was to the effect that the Chief Justice perhaps is an office, it's not an individual. And so he's sitting on the panel. He sat there as a member of the Supreme Court, in charge of her faculties, going to discharge his duties without recourse to the fact that he is acting as CJ in the absence of the very person you are seeking to get some clarity on his suspension.
See, if you listen to me very well, I have never said that whatever happened is unconstitutional. In fact, we admitted in court that it is not about the constitutionality of what is happening. It is about the inappropriateness.
In other words, fairness and independent of mind of the person.
Let it be seen. Bring out the confidence of the Ghanaian people, especially the plaintiff, that whatever is going to happen here in the courtroom will be fair and it will be just. And for that matter, you should have allowed the previous panel that was sitting on the case to have sat on it. And that brings me to that second objection.
That particular issue. And so the previous panel had Professor Henrietta Mensah-Bonsu as the presiding.
Absolutely.
Together with Samuel Asiedu, now on the committee that has been set to probe into the petitions against the CJ. And then also Ernest Gau, who is also part. Yao Asare Dakun was changed. So was Richard Ajay-Frimpong. Now the new addition included the acting CJ, Bafuboni, His Lordship Bafuboni, Justice Henrietta Mensah-Bonsu, Justice Yoni Kolende, Justice Amadou Tenko. Interestingly, all the new additions did not find merit in your application before the court.
So you see,
and you think that they did so because of some other interest rather than straight application of the law.
Okay? These are your words. You are a journalist, a neutral person, and you see the kind of conclusion you were able to give.
No, I'm asking you whether you think that
because you have given that conclusion because of what you have seen, not what I am saying. So, in the deepest of your heart, you know that what has happened, even if it is constitutional, you are not seeing that indeed justice is being served. Even if whatever they told the court or whatever they told the parties is constitutional, is legal, and it is even right, in the deepest of your heart, you are not satisfied whether indeed justice is seen.
It's actually not the case. I'm only making reference to the fact that
if you say
I'm also making reference to
those are your words. Those that were included.
They came in new, and I mean it's a matter of public record that the three new additions voted to dismiss your application. On the other side too, the other two voted for your application. Will you say that they did so because of whatever?
That is why I'm saying.
In this case, isn't it the straight application of the law that is at play here?
That is why I am saying that if there is an opportunity or an opportunity brings itself for an acting CJ to be able to make sure that in the dispensation of justice, you do not bring into the minds of the Ghanaian that what is happening is not just constitutional, but also just. That what is happening is not only legal, but it is also fair. The bench has that responsibility to create that impression to the Ghanaian people so that we do not have doubt in our justice system.
All right.
And so it was my respective opinion that the acting CJ ought not to have re-empaneled or reconstitute the panel that was already hearing the matter, because this matter has been adjourned about two times.
Right.
Today was our third day in court. The first 2 days that we were in court, this was not the bench. What is so grievous, or what makes those judges that were changed incapacitated to have sat on the matter?
Apart from perhaps the only person some explanation can be preferred is Samuel Asiedu, who is now sitting on a 5-member committee that is looking into the petition against the suspended CJ. The other two is...
What reason do you want to give to Asiedu's own?
He is on a panel.
Because, you see, don't get it wrong. No, hold on. He has already been constituted as a member
of the 5-member committee.
No, hold on. He has already been constituted as a member of the bench that was hearing our matter. What His Excellency President Mahama sought to do by including Asiedu in the membership of the committee,
the 5-member committee,
yes, was to replace Asiedu on the bench, which he has no power to do so, because you already know that the matter that is before the bench or that is before the court, he is a member of the panel. Why do you go and add him to the committee? So you see, the point is that Asiedu should rather not be part of the committee. In fact, he should have recused himself from being a member of the committee, because he was already a member. You see why I say...
On this panel.
You see why I say that almost everything that is happening seems to be choreographed. It seems to be choreographed behind the scene. Because why would the acting CJ take off Asiedu? Then, why would the president also make him part of the committee that is supposed to hear the matter of the CJ, knowing very well that Asiedu himself was part of the bench? So,
let me allow...
Justice, unfortunately, I do not see it seem to be done. When on the 21st
I'll come back to you because
because we have not even gone into...
No, we have not. This is just the prelims.
Matter.
Yes, so let me allow other opinions on this particular matter. And of course, former director of the Ghana Law School, Mr. Ansari, also joins me on phone. Mr. Ansari, good afternoon and welcome to the program. We don't seem to have his attention. Mr. Ansari, director of the Ghana Law School. Sir, if you can hear me, good afternoon.
Good afternoon, my brother. How are you?
I'm doing good, sir, and it's good to have you here.
Thank you for having me.
So I'm guessing you've been listening to the arguments by Honorable Vincent Asafua, who went to court with the former Attorney General, seeking certain action by the Superior Court of Ghana. Now, the court, in a 3-2 decision, first dismissed the application that was seeking to injunct the president from suspending the Chief Justice. But before that, they had raised issues with the inclusion of the acting Chief Justice on the panel that decided this case, because according to them, he stands to benefit, or he's already benefiting from the vacancy created by the suspension of Gertrude Tokono. What is your take on this argument that they put before the court, which was unanimously rejected?
Thank you very much. You recall that when my good friend filed his application and you had me on your show, I did say it was dead on arrival. A constitution does not allow the reversal of the where the suspension was done in accordance with. In fact, on grounds of public policy, it is in the best interest of the nation that once a committee has been put in place, the committee will be allowed, to do its work to completion. Nowhere in the Constitution has it been said that, anyone feeling aggrieved can go to the Supreme Court and ask the Supreme Court upon an application brought by the person or even sole motive to reverse the suspension. Nowhere. And indeed, it would be unconstitutional for the president to even attempt to reverse the suspension. So as far as I'm concerned, that application was one of the applications, with a dead hand, in it. That's my view. Now, having listened to my friend's argument on the empaneling, the CJ, Justice Leadership Tokonu, did empanel. Yes, right. Because it was, a constitutional right so to do as the head, of the judiciary. Now, there is an acting Chief Justice. And administratively, he and he alone, that is the acting CJ, has the most say now in issues of empaneling or composing justices to sit on this matter. Only the acting CJ, no other person. In the absence of the acting CJ, the most senior justice of the Supreme Court will have to carry out the administrative duty. So no one can fault the acting CJ for deciding to sit. The CJ could have sat, and in fact, on many occasions, we have questioned why the head of the judiciary has not been sitting. Justice Georgina Wood used to recuse herself for reasons best known to her. But that doesn't mean that other justices must toe her line. If Paul Bafuboni feels that he has to sit and he has sat, it is within his constitutional mandate so to do.
But in terms of the morality of it,
that the applicant may go further and ask for a review of this decision. So let us not go into the merits as to why they did that. But let us ask ourselves a simple question: does the Constitution allow a reversal of the suspension? And if so, which particular article in the Constitution says that after the president, has suspended the Chief Justice, an application can be brought seeking to reverse the suspension? Where is it written in black and white in the Constitution? If it is not there, it means it is not there, and therefore it cannot be done. Simple.
I was thinking I can have you some few minutes on the issue of fairness and the proprietiveness of the inclusion of the acting CJ on the panel that decided the outcome of this application, and the fact that the lawyers for the applicant makes the point that for fairness and neutrality to prevail, he should not have been part of the panel because clearly he's already benefiting from the absence of Gertrude Tokonu.
Well, for fairness and neutrality, the application ought not to have been brought in the first place. But to answer the question, there is a doctrine in law, known as or referred to as the doctrine of necessity. Necessity. And acting upon the doctrine of necessity, the Chief Justice or acting Chief Justice may decide to sit. And it is not wrongful, to do so.
Even though he may be conflicted in a way?
For the CJ herself to sit or for the acting CJ, and it is fair. Fairness is relative.
Even though he may be conflicted in a way?
It is not objective. Fairness is in the mind of the sayer or user of the word. I'm saying that the doctrine of necessity allows the acting Chief Justice or even the incumbent Chief Justice to sit. But if she had not been suspended and she chose to sit, she wouldn't have erred, and therefore, if in like manner the acting Chief Justice chooses to sit, he hasn't erred. So the issue of fairness does not arise. It is a constitutional mandate. The Constitution mandates the head to empanel, the head herself or himself inclusive.
And then on the substantive matter, 3-2 the outcome, meaning that, it is a matter that could have gone anyway. It was not a clear-cut decision for the panel. Some held the view that the applicants had a case. The 3 additions that came through, all voting against the application.
Well, I'm saying that as a lawyer, the application was legally, wholly unmeritorious. It was without, any merit. And I said the day it was filed that it was dead on arrival, and I reasonably expected, any bench to throw it out because, it has no support. It cannot find any support in the Constitution. Allow the process to continue to completion so that it will be a precedent and it will prevent people from just submitting frivolous and vexatious petitions to the president. So let's allow, the process, to come to, a completion in order to know whether the allegations, are meritorious or not. Maybe, there's nothing in the allegation, and then the petition, will fail, and the CJ, will be asked to resume. If there are merits in the petition, on the other hand, and the petition succeeds, then the CJ is removed. Let us allow the process. Now, if we curtail the process, songs are going to work as to why the president did that. For a full implementation of what is going on. Let us see it to the end, and then we know whether what has been said about the CJ is true or false. If you curtail it, it will be lingering in the minds of the ordinary Ghanaian. What kind of justice system is this? Let us avoid that.
All right.
Let us see it to the end, and then we all know. But as to whether it is fair for A to state or B not to state, I leave it to the judicial conscience of the individual justices who sat on the matter. It's not for we mortals to say so. It is for they themselves. If it is fair for them, or there's some merit in the applicants saying that they shouldn't have started or not, we leave it to them. It is not for us to say so.
I appreciate your time very much. Sir Kwaku Ansansare is former director of the Ghana School of Law. So, Vincent, you've heard him.
Saying the same thing. Are we not saying the same thing? I sat here and told you that we are not questioning the power of the the acting CJ, to empanel the judges. We are only saying that, as the saying goes, please, let justice not only be done,
but to be seen.
But let it be seen to be done. Okay, breathe in confidence in our judiciary. Make sure that the integrity of the judiciary is intact, so that any bystander anywhere, when he sees what is being done in court, may not only be interested in the legality or the constitutionality of what is happening in court, but will also see the need of fairness and justice. And so that's the point I've been making. And I think that we've said the same thing. The only thing that he's saying that is different from mine is that my matter was dead on arrival.
Yes,
you know
that is what he says.
That it cannot be dead on arrival because we are having 2 justices at the Supreme Court who see reasoning
with your position,
the potency of the arguments that we made in court. On what basis can he say that our matter was dead on arrival? It cannot be. The point that I have been drumming home is that every CJ or any person who is acting in his or her stead has the same power to do whatever the CJ will have to do under the Constitution of the Republic of Ghana. And so, our objection was in no way stopping the CJ from doing what he ought to do. But it would have been appropriate, it would have been good for his own integrity, for the integrity of the court, for the confidence of the Ghanaian people, to see that whatever was going to happen in court was going to be just was going to be fair. It was not only going to be constitutional. It was not only going to be legal, but the Ghanaian people will see that indeed we have a justice system that is robust, and that is our point, and that is what we were seeking. And I cited this example to you, even apart from the Tufo versus Attorney General and the J. Trim examples. I cited an example to you in terms of the principle as far as Georgina Wu's situation was concerned and how she handled the matter. Nothing has stopped Georgina Wu, the former Chief Justice, to have sat on the election petition that the New Patriotic Party took to court. Nothing has stopped her. Nothing also has stopped her from even empaneling the sort of judges who should sit on it.
Right.
But see, if you are an acting CD and we have a panel of judges that is sitting on the matter, then as soon as you have been appointed, you change the members. And all those members that you brought in, including he himself, voted against our injunction. Whatever the basis may be, and listen to me very well.
And the reason they say will come out on the 21st of May.
As an officer of the court, whatever the basis may be, it may be constitutional, it may be legal, but in the minds of an ordinary person, have you been able to create that impression that there was fairness, that there was just, and that I, as a Ghanaian, and even investors should have confidence in the judiciary or the justice system?
The reason, unfortunately,
that threshold has not been met. And it is disappointing.
The reason, unfortunately, according to the court, will come out on 21st of May. So it's unclear the reason behind the decision they took today. But you were in court seeking what exactly? To get clarity as to what time a sitting Chief Justice should be told of a petition against him or her?
You remember we went to court on two matters. The first injunction application that we sought from the Supreme Court to hear our prayer was that the Supreme Court should stay the hands of the President from proceeding on the processes that it has started. Because at the time, you remember, His Excellency the President, upon receiving the petition, had not ferried the petition to the Chief Justice. The February letter that emanated from the office of the President only said that they have triggered the consultation processes. Our position at the time, which we did so by way of the initial injunction, was that please stay the hands of the President. But today, when we went to court, we withdrew that aspect and went ahead with our second interlocutory injunction, which sought to suspend the suspension of the Chief Justice. What was the basis? Our basis is that, yes, Article 1466 says that the automatic procedure that should follow after a President of the Republic has received a petition is to go and consult the Council of State. That is what Article 1466 is saying.
Right.
But you and I know that the Constitution since 1992 needs review, and for that matter, case law has come to, as it were, fill in the lacunas that we find in our Constitution. So my submission to the court was that anytime a petition is received, the President ought to ferry the petition to the CJ even before any consultation whatsoever will start.
And the court asks you in this case, because you took this matter to court,
right,
to point out the exact provision in that article that talks about timelines within which the CJ should be informed.
You see,
and from what we have been told.
That was why I was scandalized, and that was why I was surprised. And with the greatest of respect, it was coming from my own boss, someone I practiced from his own chambers. When Kolindi was asking this question, I was surprised why he was asking that we should point to him in the Constitution.
Because there's none, actually.
Listen, please. When you are supposed to find a prima facie against the president, do you find that in the Constitution? Against the CJ, do you find that in the Constitution?
Not exactly.
Today, if there's a petition to remove the Electoral Commission, has that process been well defined in the Constitution? I'm asking you. Today, if there's a petition against Jane Mensah, the Constitution has not provided for any procedure to remove the Electoral Commission. Mm-hmm. Is that not the case?
It is.
It was a matter of case law, one, and interpreting the Constitution purposively in accordance with the Interpretation Act of Ghana, that in interpreting the Constitution, you need to do so by way of the combined effect of the letter and the context. And also, when SOA, JSC said in the 24 versus Attorney General, that in reading the Constitution, please make sure that you do so by the letter and the spirit of the Constitution. It is on that basis that a lot of meanings have been read into our Constitution to give meaning to it so that it does not result into absurdity. So I disagree with the court when the court even asked that question, that because it has not been stated in the Constitution, then it means that that is not legal. No.
So, Honorable
that
Asafua,
is not our jurisprudence.
So, Honorable Asafua, what is next for you as far as this matter is concerned, or the case, or the door is closed?
Well, the door cannot be closed. If you meet a bench, 5-member panel, who says that the potency of your argument is apt, and for that matter, I go with what you say, 2 of them. 3 saying that I disagree with you. It only gives me some impression, and it gives me some comfort that the reasoning for me going to court has some merit. And so
you're going for a review?
And so, if on the 21st of May, I see the reasoning behind the ruling, then if I'm not satisfied, then I am likely to file for a review.
A review of this case.
For the court to review its own decision.
All right.
That the decision that it gave cannot be made to stand. It does not bring about the kind of fairness and just that we want to see in our judiciary. We'll
leave it here for now and wait for the decision or the reason behind the decision of the court to be made known on the 21st of May, and then we'll further the discussion on this matter. Let's take a short break here on the point. When we return, we'll talk about the police and what they've been telling us this afternoon. Vincent, thank you so much for coming through.
Thank you so much.